Hello, everyone, and welcome to Current Issues in Animal Law, a lecture series brought to you by the Environmental Law Center at Vermont Law School. I'm Jenny Rushlow, and I'm Director of the Environmental Law Center and Associate Dean for Environmental Programs at Vermont Law School. We will have time for questions and answers after today's presentation, so please do type your questions in the chat box at any time during the lecture, and we'll get to as many as we can in the remaining time. Today, I'm very pleased to welcome Professor Randall Abate. Randall Abate is the inaugural Rechnitz Family and Urban Coast Institute Endowed Chair in Marine and Environmental Law and Policy, and a professor in the Department of Political Science and Sociology at Monmouth University in New Jersey. He also serves as the director of the Institute for Global Understanding at Monmouth. He teaches courses in domestic and international environmental law, climate justice, constitutional law, and animal law. He joined their faculty in 2018 with 24 years of full-time law teaching experience at 6 different law schools. He's published 6 books and more than 30 law journal articles and book chapters on environmental and animal law topics, with a recent emphasis on climate change law and justice. He is very recently the author of the 2nd edition of his book, What Can Animal Law Learn from Environmental Law, which is published in July. And the book that he published before that was entitled Climate Change and the Voiceless. He holds a BA from the University of Rochester and a JD and a Master's of Environmental Law and Policy from Vermont Law School. Today, he will present a talk titled Animal Law and Environmental Law, Parallels and Synergies. Please join me in welcoming Professor Abate.
Thank you very much, Jenny. I am sharing my screen now. Okay, very grateful to be here. Thank you again, Jenny, for the invitation. It's always exciting to re-engage with my alma mater, VLS. It was a little sad thinking about how long it's been since I graduated from VLS. That kind of dampened my mood a little bit. 32 years since I graduated, and it's been wonderful maintaining those ties with VLS throughout my career. Very happy with and proud of the environmental law education I received at Vermont Law School, and always welcome the opportunity to be a part of the excellent events that VLS hosts. So I'm delighted to be here today to share a book talk about the 2nd edition of my book, and just to give you a sense of the coverage I plan to navigate in this time we have together. I want to give you a sense of how I came to this book project. So the original book was published in 2015, and the 2nd edition, as Jenny mentioned, was just published last year. And so I want to take you through some of the history and politics and legal developments that are at the foundation of these 2 movements, and share how those foundations have led to very different trajectories for environmental law and animal law. And then I want to go through some select lessons that animal law can use to piggyback, to use the animal analogy, to build on the path that environmental law has blazed in certain areas. Environmental law being the more senior of the 2 movements, it's certainly excelled in certain ways that are important for animal law to be able to capitalize on and similarly succeed in those areas. And certainly information dissemination and standing are 2 primary areas there, but the book covers many others as well. And then another theme of the book is the opportunities for collaboration between these 2 movements. That climate change is a very powerful common space for the 2 movements, and that needs to be leveraged more, especially today more than ever. And how the 2 movements really have a lot in common in terms of common goals and means, and there ought to be more of a sharing of strategies and synergies there. And so the talk will conclude with a brief reference to two of the chapters that were added to the second edition. So I did it the hard way. The first edition was 17 chapters, and most people, when they prepare a second edition, they merely update the existing chapters. And that was just a small piece of the task I took on in the second edition. So the second edition added 12 new chapters in addition to updating the original 17. So these are two of those 12 chapters that I'll be um, highlighting for you at the end of the talk. So starting with how I came to the movement of animal law. As I mentioned, I was educated at Vermont Law School, and there was not, again, dating myself here, there was not an animal law course in the curriculum when I was in law school. I do believe Steve Wise was the first one to teach animal law in Vermont, and that was after I graduated, maybe in the early 90s. Um, but I was very much all about environmental law in my legal education and in the first 2 decades of my career. Originally focused on domestic, but then transitioning to international environmental law in my teaching and writing, and then got more laser focused on climate change and climate justice issues. So I made this transition that many environmental law professors don't, and I wish more of them would. Uh, Transitions to also teaching animal law. In 2013, I was approached by a student leader who was the president of the SALDIF chapter where I was teaching at Florida A&M Law School. And I was asked to teach the first animal law course at that school. And so I prepared that course over the process of maybe about a full year. And in that process, that's where the seed for this book project had been planted. Essentially, what I was seeing in preparing to teach an animal law course for the first time is that there were so many things about animal law that I knew from environmental law that had been encountered and overcome in decades prior in the animal law movement. And so that really sparked an interest in me to say, well, that seems to be a nice path for animal law to go down, and why isn't that happening? And so ultimately that was the primary focus of the book, but the more I got into ultimately completing the book, I almost wish that it had this bifurcated focus even reflected in the title, which is about how the movements can cooperate and collaborate a bit more in addition to animal law, um, piggybacking on the success of environmental law. So those are really the two themes that certainly go through the second edition, the 29 chapters in the second edition. So history certainly has a lot to do with the different trajectories of these two movements, and so the starting point here is um, environmental law exploded. Federal environmental framework really just came onto the scene in a very short period of time in the 1970s. And that the reason for that was not because we had this moral awakening that we needed to be better stewards of nature and recognize the intrinsic value of nature. It was driven by the threat that we were posing to our own health and safety with the massive pollution load we were generating. So contamination of the air, water, land, very visible crises, very palpable crises that were a threat to our health and welfare. Um, a river catching fire in Ohio, and smog so thick in LA that you could barely see too far in front of you, and the Love Canal crisis, um, the response to which was the CERCLA law. So there was a lot of reason for an aggressive environmental law response to these challenges, but they were premised on the notion of we're protecting ourselves from the pollution threats that we've caused in the environment. And when you think about that, there's not a readily transferable opportunity for that logic to apply to animal law. Um, and also was the transboundary nature was a big piece of the impetus for this federal environmental framework. When we think about animal law and how it got started and how it remains very much in its focus, it's a moral imperative in many ways. This idea of protecting animals who cannot protect themselves, very much a welfare driven agenda, certainly has evolved also into animal rights agenda. But where animal law has struggled is that it's a less obvious connection to being in humans' interests, whether it be health, welfare, or just quality of life. It's clearly not as directly in our interest to protect animals as it is to protect the environment in which we find ourselves. So that was a challenge that translated, followed animal law into the political realm. When you think about what Congress or a state legislature is going to be willing to fund and have the political will to do, again, it's going to be issues that are more closely tied to human priorities. And if it is about just protecting animals for their intrinsic value, and out of respect for their dignity, that's not going to be high on the legislative agenda. And so that was very much an advantage of environmental law, that not only was it closely tied to human interests, but it had that transboundary nature that really required an effective federal response. And then on the legal side, in addition to this federal legislative framework issue, there's also the notion of science, how that explosion of federal environmental law in the 1970s was grounded in very reliable science that was not in dispute, the way we see climate science being disputed to this day, unfortunately, even though it's every bit as clear. Um, and so with animal law, we don't have that same body of science that drives the reason why we need animal law protections the way we do for environmental law. So it's getting better. There's a growing field of sentience science that's supporting the animal law movement's objectives now. So the more we understand that animals are not so different from humans, that scientific support is going to be quite valuable in getting that political will and that legislative agenda mobilized. And that's a that's a process that's going to take time, given how many pressing priorities we have on the legislative agenda in the era of COVID and climate change. But there's an opportunity to link some of these things about protecting animals and still advancing our interest in fighting COVID and fighting climate change. You don't have to think too hard to see those connections, and so there is an opportunity, in addition to just understanding animals as being not so different from humans, as another reason why we need to be protecting them more effectively. So the evolution then of animal environmental law was initially rooted in this notion of respect for the intrinsic value of nature, and it's a shame we didn't stay there, because that was very right-minded thinking when it comes to how we ought to be protecting the environment, with wilderness protection efforts, and aesthetics-based protections, national park regime. All of this was late 1800s, early 1900s. And then there was just this big block of time where it was largely a state domain of environmental protection when we talked about pollution control, and common law claims like nuisance and trespass. And then that federal environmental revolution in the 1970s, that second box, with the human health focus, both at the domestic and the international levels. And then more recently, we're in more of a rights period. So this really started with the environmental justice movement in the late 1980s. And this is both happening in the US and in many countries around the world, that there's a connection now that environmental protection isn't just about this scientific control of pollution. It's really more about how human rights are impacted by the way we are destroying the environment, and how it is very much a human rights challenge now. When we talk about environmental protection, it's not just clean up the mess and go on with status quo. It's very much intersectional, and climate justice really represents that thinking where we are today. So animal law, very different trajectory. We had certainly some success. The animal law movement has worked very hard, and they fought to get anti-cruelty protections in all 50 states, and that's certainly a significant milestone. And that was achieved perhaps maybe 5-7 years ago now, that the 50th state came on board. And there's more and more felony provisions available now, as well as significant misdemeanor protections in all 50 states. And that's not nearly enough, though, when we think about effectively protecting animals. So When you think about the federal domain, the second box from the previous slide, here we have virtually nothing at the federal level to protect animals. Acts that are, not even trying that hard to protect animals. The Animal Welfare Act excludes a significant swath of vulnerable animals that ought to be protected, specifically those in research and in animal agriculture. And then you've got provisions like the Humane Methods of Slaughter Act, and the 28-hour law that are just the bare minimum levels of protection for animals that are ultimately tortured until they're slaughtered. I mean, it's almost an oxymoron to call those animal law protections in those statutes. So what we've seen is a very robust movement of late in the animal rights domain, even though animal law doesn't enjoy that firm platform of a robust federal animal law network framework the way environmental law does. The animal rights movement has really taken off and is very ambitious in what it's seeking to accomplish, and has succeeded in some ways. And it's important to recognize that it's not just the victories in court that matter. It is about the promotion of this cultural shift in our thinking about animals and what these lawsuits represent. The non-human rights projects efforts to use habeas corpus as a rights-based tool for animals, and PETA's efforts with the monkey selfie case and the Tillicum case. I mean, different creative ways of using litigation to raise awareness of the plight of captive animals. And even if the cases don't win, and they're very difficult to win, they are winning in the court of public opinion to change a culture of mistreatment of animals. So as far as the select lessons go, we'll start with information and then turn to standing and personhood. So one of environmental law's greatest successes, and it's sometimes overlooked because we have a lot of very effective environmental laws that are effective because they have very robust enforcement frameworks, and that's not to be underestimated. That's fantastic. But what is really powerful and unique about the U.S. federal environmental laws compared to those in some of the other countries around the world is how it's grounded in information, and how transparency and accountability is so powerful in how these laws are structured. So, one example of that is discharge monitoring reports under the Clean Water Act, how if you're regulated, you are required to disclose your discharges, the amounts of your discharge per the terms of your permit. You're essentially required to admit publicly when you have not complied with those limits, and that is public information for environmental advocacy groups to use to sue to compel compliance. And then you've also got community empowerment mechanisms like the Emergency Planning and Community Right to Know Act, that there is an opportunity for the public to be informed of potential threats to their health and safety through that mechanism. So access is very, very important, that the public's right to be able to get information that they need. And that's a very powerful tool in protecting the environment and protecting themselves from environmental threats. And then the dissemination piece is equally powerful when you think about how successful NEPA has been. I mean, who would have thought that a statute without an substantive enforcement mechanism would be as potent as it is? But that process of disseminating the information that federal agencies are required to do under NEPA to disclose the extent of the potential environmental impacts that would flow from these projects moving forward, it's a very potent tool for delay and publicity. So both of these things can potentially kill a project that would otherwise be environmentally harmful, even though there is no way to compel that project to stop under the terms of NEPA the way you would in another law with a substantive enforcement provision. So when you think about those two aspects of information, access and dissemination, and how valuable they have been for environmental law, we don't see anything like that in animal law. And that's really a huge distinction between these two movements, that we have quite the opposite with animal law. We have laws like ag-gag laws that are essentially designed to bar information access, and not just bar it, but criminalize the effort to gain access to how factory farms are operating, by trying to gain access through video and photography and you know, filling out a job application to be able to access these facilities. Um, the the Facilities Act behind this iron curtain, cloaked in secrecy, that is the opposite of what we see with how the environmental laws operate in terms of transparency. And so when you think about how could this be overcome, well, it is about mobilizing the public in a way that would ultimately drive down demand for these products. I mean, we still live in a very meat-based culture. And so if there's any way to promote a campaign about labeling of meat, when you think about how effective tobacco labeling and labeling of other products that are things that people choose to consume but are harmful, that's certainly one way that there might be an opportunity to get behind the iron curtain of industrial animal agriculture. So it wouldn't have to be images of factory farmed animals on your package of ground beef, but it could start with something like a carbon footprint label, that just getting information to the public about the implications of their choices, even if it is just implications to the environment or to their health, um, could be a very effective tool. And there's an anecdote there that I always share in this talk, and that is, I was an environmental law professor for more than 2 decades, and it never occurred to me that adopting a plant-based diet would be the best thing I could do to protect the environment. Did not cross my mind until I taught animal law. So that says a lot about lack of information about impact of dietary choices, and how getting that information to the public, even those who should know better, who are teaching in these areas, um, it's a very, very potent tool to drive down demand, and that's ultimately what's going to close down the factory farms far sooner than any government initiative would. So standing has been another legacy of largely success in environmental law. It certainly has its challenges. We're unusual, the U.S., in that we don't have these universal standing um, provisions the way other countries do. That we have this Article 3 requirement that never goes away, and those three elements of standing are very hard to establish. But one thing that has helped environmental law a bit is certainly a robust range of citizen supervisions under these federal environmental laws, and that greases the wheels a bit. It waives the need to establish those compliance with those jurisprudential considerations that go beyond the Article 3 minimum three elements. And also, it's an issue where animal law is just in a fundamentally different place, because to establish animal law standing, in most instances, it's about a human alleging that harm to an animal has somehow harmed that human plaintiff. And that's an extra step that environmental plaintiffs typically don't face. And so um, big development in the 1970s with environmental standing was, we got out of this box that injury only means physical or economic injury. There was a great body of case law that recognized environmental interests do establish injury, in the way of conservation interests, um, aesthetic interests, recreational interests. And we don't see those parallels with animal law, although we should. And that's just a work in progress, and that's where animal law lags behind in gaining access to the courts compared to environmental law. And another piece of that is this notion of stewardship that really applies to both movements, but environmental law is way ahead on that, in part because there's doctrines like the public trust doctrine that identify the government having this fiduciary duty to protect the public, to manage resources that are in the public's interests on behalf of the public. And then you've got the Massachusetts v. EPA precedent that stands for this notion of a state having this ability to sue on behalf of its citizens for loss of threat to the integrity of its territory. So we don't have parallel opportunities like that in animal law, although one chapter in the second edition of my book does argue that there is now an opportunity to perhaps do more with applying the public trust doctrine to protection of fish and wildlife, for instance. It doesn't have to be as narrowly construed as it is, and that could open up an opportunity for enhanced protection of wildlife. So legal personhood is another dimension where environmental law, once again, is ahead of animal law. There's widespread recognition that you don't have to be human to have legal personhood. So corporations and ships, examples of that, a movement now in Europe for artificial intelligence to have legal personhood. But interestingly, there's been an explosion of success in the rights of nature movement, where rivers and other natural resources have been determined to have legal personhood. And I'd be scratching my head too, in the sense that if the law is recognizing a river as having legal personhood, why would we not also confer that kind of legal protection to animals, particularly primates and higher mammals? And not surprisingly, that's where a lot of these animal rights cases have been focused, that the closest to humans and what science tells us should arguably be the starting point for getting personhood to trickle down into the animal kingdom. So these are just some examples of the personhood for natural resources that have been successful in New Zealand, legislatively enshrined, in Colombia and India through sua sponte decisions by courts, which was really interesting. You didn't even have plaintiffs asking for legal personhood in those cases, and in both instances, the court, on its own volition, decided that the rivers in those instances should have legal personhood for more robust protection. And there are efforts underway in Australia. The Great Barrier Reef as an ecosystem personhood concept, and that is has already been recognized in the Colombian Amazon in a climate justice case, granting legal personhood to the Colombian Amazon. Chapter 29 in my book does talk about the effort underway in Australia to try and the challenges that it faces in Australia to protect the Great Barrier Reef with legal personhood. So it's always important to remember, because the word person is built into this term, that legal personhood is only about the law's recognition of who matters. And it's very easy for the law to ultimately conclude that animal lives matter, and therefore they are going to be legally protected. It's not about being equated to humans, and that's where a lot of the false logic comes in, combating personhood, opposing personhood for animals. It's that, well, humans and animals are fundamentally different. Animals can't get married, they can't vote. So why would we give them personhood? And that's just false logic. So the challenges, though, the slippery slope arguments are things that are standing in the path, certainly not insurmountable, but things that have to be reckoned with when we talk about animal personhood. This is ultimately going to be a legislative judgment. And those who say, well, it's very difficult, therefore we shouldn't try, just think about the kind of place we'd be in society now if all legislative protections that were difficult to achieve we gave up on because they're difficult. That's really what the logic is here, that just because it's a bit of a slippery slope about how far down into the animal kingdom we might go with legal personhood protections does not mean that we shouldn't start somewhere. And then, of course, there's these moral challenges as well, that personhood for animals certainly is not going to be anything close to the robust rights that humans enjoy. And therefore, there's this concern of creating sort of a second-class citizen status. Back in the days of slavery, being 3/5 of a person, it's just morally repugnant to think that way. But that was humans versus humans, and that certainly was morally repugnant. But here, it's about recognizing, at a minimum, this notion of right to be free from confinement, right to be free from torture, if we're talking about personhood rights for animals, recognizing that they are different from humans in their roles in society. They should not have to bear responsibilities just to be able to enjoy rights. I mean, think about, there are lots of categories of humans that enjoy rights without responsibilities. If you're an infant, if you're in a coma, if you're severely mentally disabled, you're enjoying rights and not bearing responsibilities the way the rest of society does. And there's nothing wrong with that. The law protects that. So this is more of a philosophical view on all of it, but we might be at the point now where we're just ready to morally evolve to accept that legal personhood for animals is really where we ought to be. I mean, it wasn't that long ago when we used to have people as property, whether it was with slavery or women being deemed the property of their husbands. And then this long shadow of discrimination that persists to this day, treating people differently on the basis of their status. And the law has responded with protections. That doesn't mean it doesn't happen, but the law is protecting against those morally repugnant behaviors. And likewise, the exploitation of animals is every bit as morally repugnant, but somehow we're not quite there because they're not humans. And that's a big cultural leap that's still in the works. So in terms of these two movements collaborating, climate change and strategies are two of the efforts that really should be undertaken. So CAFOS, concentrated animal feeding operations, when you think about the impact that they have on the planet in accelerating climate change, there's all kinds of land and water pollution problems associated with them as well. But just the climate change piece is an area where these two movements could coalesce more effectively. And there's all kinds of greenhouse gas emissions coming from these facilities, but just methane alone could be more of a focused target for these two movements. It's easy to coalesce on how important it is to phase out CAFOs as soon as humanly possible. And it's absolutely in both movements' interests. Of course, the animal law movement takes more of the animal welfare perspective about how horrific these facilities are for animal treatment. And the environmental movement, a bit more plugged into to the environmental impacts and the climate change impacts, although not to the degree they should be on the climate change side. And then, both movements can agree that the public health challenge that the CAFOs and the meat-based diet in our society is causing certainly is something that needs to be phased out. So the other piece about strategy is that, as I mentioned earlier, both of these movements really at a fundamental level are about stewardship. They're about protecting the voiceless, about using the law to ultimately protect entities that do not have legal protection for their interests. And so that doesn't mean a river or a cow is going to go into court. This always involves human guardianship to represent the interests of the voiceless. And again, we've got robust examples of that in our legal system already. When you think about a custody proceeding for a 3-year-old, there's going to be a guardian ad litem appointed to represent the best interests of that 3-year-old. The 3-year-old doesn't say, mommy's the more fit parent. So there's all kinds of guardianship precedent that could be applied in representing these interests of the voiceless, whether we're talking about animals or natural resources. And so that is the foundation of the litigation efforts. It really is about trying to have more respect for the intrinsic value of these resources and these animals. And what can be done better in both movements, which is very much a thesis in my Climate Change and the Voiceless book, is that even if we take an anthropocentric lens, it's very much in humans' interests to do a better job protecting wildlife and natural resources. It promotes resilience, and all of us need resilience to be best positioned to combat climate change and the threats that it's posing. So the other piece ultimately is that demand reduction role that both movements, I mean, animal law does this much more effectively, but really both of these movements are trying to raise public awareness to help wean society off of its bad habits. So in the environmental field, that might be the perils of fossil fuels. And on the animal law side, that is certainly the perils of CAFOs. And those two interests you would think are quite similar and would be collaborating. And I just published an article last month that looked at these two industries, fossil fuel and industrial animal ag, as what I call common enemies, that ultimately they have the same track record in their impacts, how they ultimately proceeded in disregard of the knowledge of their impacts, and even went a step further and actively misled the public about the nature of the climate change impacts from their activities to ensure their profitability. And so they're being sued, as it should be, for those efforts. And that's a process that's underway right now. But those cases by themselves are part of that demand reduction campaign. That when they get exposed for what they've done and the harm that's associated with it, and the level of evil behind it to persist in something so harmful and misleading the public about it, that's where people are going to be more motivated to transition to fossil fuels and a plant-based food system. So all of that effort is very important and should not be proceeding in silos. There's a lot of creativity and persistence necessary to succeed in these two fields, and they need to be sharing resources and comparing notes. So lastly, the case studies from the second edition that I want to share with you. One is about information and deception, and the other is about this transition to away from factory farms. So with deceptive advertising, as I mentioned, information is so key to public awareness, public decision making, and ultimately how that could help us transition away from harmful activities. And so the private sector is very aware of that. They plug into the fact that, wow, we've got pretty educated consumers now. Let's play into their interest in being informed consumers, and we'll just lie to them that they're buying something that they think is good for the environment, for instance, with greenwashing, and ultimately it's not. And fortunately, these efforts have been called out and made accountability for these efforts. You're certainly familiar with the Volkswagen scandal on the greenwashing side, and that's been going on. Other efforts with greenwashing have been going on for decades now. And fortunately, there was an effective legal response there with the FTC's green guides as a way to manage that effort, that campaign on the private sector on the greenwashing side. And now we're seeing the same thing all over again with humane washing. Same private sector effort to play into these informed consumers. We're going to tell you that your chicken has been humanely raised, when in fact, in a lawsuit, the humanely raised chicken was processed no differently than the regular chicken. It just cost more. And it had a label that made the consumer feel better. And caring dairies, another deception technique, and they're everywhere in the advertising campaign on the animal law side. So these two campaigns, the chapter in the book in the second edition is looking at how there's a lot of commonalities here that humane washing can really try to build on the success of greenwashing's the response to greenwashing, and how this is really a win-win-win when we're able to combat these deceptive advertising practices across both movements. It's good for animals, it's good for the environment, it's good for public health. It's what we need to be doing, and the more collaborative we can be there, the better. Lab grown meat is an interesting topic, and I learned a lot about this when my contributing authors submitted this chapter. Um, So for me, as someone who's plant-based, I had an initial reluctance about lab-grown meat because it seems like an intermediate step that might not be necessary, but certainly it's far better than the status quo. No one's going to argue with the fact that it's a massive improvement for animal welfare, environment, and public health concerns when we compare it to factory farming. Um, and it's certainly going to be a stepping stone to get us to plant-based food system if that's the ultimate goal, or at a minimum, very small scale, sustainable animal agriculture and plant-based. Um, and the fact that it really does resemble the traditional factory farmed meat in taste most directly, that's going to get the transition away from the status quo with factory farming. I mean, a lot of people are interested in doing the right thing, but they're not willing to sacrifice much. So it is about making that transition as seamless as possible, not have to sacrifice anything in taste, and then you're going to get people on board. Or sometimes you can just trick them, like I gave my father an Impossible Whopper. He's a diehard steak eater, and he didn't even know he was not eating a regular Whopper. So, sometimes deception is good if your intentions are all right. So disadvantages, though, this was what I was not as aware of, that, well, I was aware that it perpetuates the paradigm of animal exploitation. I mean, if you think enough about that, that's lab-grown meat is kind of like methadone is to heroin. You're treating the symptoms and not the disease in many ways, if you're perpetuating an addiction to something that shouldn't be happening. Animal cells are used for lab-grown meat. So again, the animal rights advocates would say there's no reason for us to eat animals, period. We can survive just fine without eating animals and deriving meat from their cells, for that matter. But the other piece that I wasn't as fully aware of is that they are energy-intensive facilities. When we're talking about producing lab-grown meat, this is bad for climate change, similar to the reality that desalination plants are not the answer to our freshwater crisis, because they're incredibly expensive, first of all, and they're massive sources of greenhouse gas emissions. So we can't rely on these technological fixes just because they seem convenient. There are a lot of trade-offs, and ultimately this transition from factory farms to plant-based is potentially possible. I don't think we're going to get there without the lab-grown meat intermediate step, but in theory, I think it's possible, especially with the developments of late with plant-based meat and milk, how comparable they are to the status quo products that, that the market is helping us get there. Not fast enough. So we need the government carrots and sticks involved as well to help us get there. And there's a lot of efforts in that regard. There was a university, Goldsmiths, University of London, that banned beef in its campus cafeterias, and that's one way to do it. And there's other ways like carbon taxes on meats, and there's similar ways of penalizing those choices, whether it be fossil fuels or industrial animal ag, so that there is a transition away from the bad habits. The government can and should facilitate that. The market is also a very important player, and one way or another, we need to get there very quickly. So thank you very much for your attention. I'm very eager to hear your questions and comments.
Thank you so much, Professor Abate. I'm taking notes to feed father Impossible Whopper, acceptable deception. Great news for my family. So for our listeners, we have a few minutes to ask some questions from our audience. And as a reminder, if you're watching on the website live stream, you can click on Watch on Live Stream, the icon at the bottom of the video, and that will bring up the chat box where you can add your question. If you're watching on our Facebook live stream, add your question to the comment box below, and we'll try to get through as many questions as possible. Our first question from the audience, Professor, is, would a Green New Deal have any direct or indirect impact on the industrial meat industry?
Absolutely. And I'm very encouraged by the Green New Deal for a variety of reasons. It created a conversation that we hadn't had in this country, and should have had for 3 decades, really. When we thought about climate change regulation initially, it was all about mitigation, like we were going to stop it or something. Soon we became aware that adaptation is really the name of the game. Climate change is going to persist well beyond the point we ever go carbon neutral, and not like that's going to happen anytime soon either. So the idea about the Green New Deal that should have been part of our thinking all along is this notion of intersectionality, how it is not just about the traditional sources that we might think of for why we are facing such a challenge with climate change. And certainly factory farms are a big piece of that challenge that we face. And there is language in the Green New Deal that talks about all of these broad-based reasons for the climate crisis and how these are intersectional challenges that ultimately racism, something that doesn't really come to mind when you think about fighting climate change, certainly a decade or two ago, is another piece of that, that ultimately the ills of capitalism on all levels are essentially what put us into the climate crisis to the degree that we're facing it. And we have to recognize it as a problem of societal choices, and how our governance system is permitting, is exacerbating these bad choices in a way that's detrimental to vulnerable communities and, of course, our planet.
Great, thank you. Our next question is, do you have any knowledge of CAFOS being breeding grounds for spreading COVID-19?
There's certainly been discussion about that, and in my article published last month, there's a section in that article that does talk about how, as disastrous as the COVID crisis has been for so many people and entities in so many ways, it's been an economic disaster, it's been a public health disaster, but one way that it offers some sense of optimism is how crippling it was as a bad publicity campaign and an economic blow to the fossil fuel industry and to factory farms. The significance of the profits that were lost in such a short period of time, and partly not just because of the supply chain disruptions, but because of the awareness of how ultimately our treatment of animals, and in the conditions like factory farms and wet markets and so forth, has put us into this challenge, and how avoidable that is, how in the grand scheme of things, what an easy transition that would be to avoid this kind of crippling crisis. I think it's been just a very powerful, and there's all kinds of research that's drawing out those links between the conditions in CAFOs and how that is a precursor to COVID and our next pandemic that's readily avoidable, that we need to regulate and ensure that we're positioning ourselves not to walk right into that.
Absolutely. Given the gains in animal law since you have been in school, how should students best prepare to enter the animal law field in this day and age?
One thing that I never allowed into my thinking in choosing my career path is, oh, you're not going to find a job doing that. And for me, that battle was, I wanted to be a law professor. And it wasn't that the jobs weren't available, it was those jobs were so hard to get. With animal law, what I find with students considering the field, the biggest challenge they face are those negative voices that say, oh, that seems like a really interesting thing to do, but you're going to be eating ketchup sandwiches your whole life if you do that as a career. And so I think one encouraging development I'm seeing is every time I go to a national animal law conference and talk to the students there, I'm seeing that a lot of them have this joint interest in animal and environmental law. And so one way that I think is a good opportunity to break into animal law is to consider ways in which environmental law might be your initial pathway into your career, and how that could lead to opportunities in animal law related career paths. So there's certainly a lot more of that happening. There also are certainly more jobs that are squarely rooted in animal law that have come out just in the past 5 to 10 years that I'm very encouraged to see, because it's a field that needs passionate, effective advocates. And the fact that these positions are often fellowships and they're funded by grants, and it's the kind of thing where you're not going to have to hang out your shingle and try to be an animal law practitioner and survive as your only option. I think there's hope there. And there's also the realm of pro bono work. I think there's more and more great opportunities to do pro bono work, and it might not be your full-time day job as a lawyer, but you can still get that satisfaction of having a really significant impact, because there's lots of great NGOs that are doing that work that would love to have your help.
Well, a natural next step from that question is a question that comes from one of our professors at VLS. Do you have any suggestions for positive actions that can be taken by the VLS Animal Law Society, which is a very active group on campus?
Yeah, I think those organizations are very well positioned to inform people not only about animal law career paths and opportunities, but about how choices can be made to better the lives of animals. And I think again, a lot of that is information dissemination to the community. And even in a community like a law school where there's much more awareness of these kinds of issues compared to the general public, I would have welcomed that during my time at VLS. I mean, it just wasn't on my radar screen, thinking actively about the concerns of protecting animals in how I conduct my life, whether it be in food choices or being more aware of exploitation of animals in certain situations. For instance, as a young father, I took my son to marine parks to see dolphin shows. I took him to the circus, and I thought this was all about, being a good father and engaging in Americana as part of everybody's childhood experiences. But if that had been brought to my attention in law school about how that is not something you want to take your kids to, I mean, you're perpetuating the cycle of exploitation by doing that, I wouldn't have done it.
I hear that. Okay, let's do, we have one more question. This one's sophisticated and specific. How would the appropriate human representative for a particular animal species be determined? Would the CERCLA provisions for the appointment of natural resource damage trustees serve as a framework?
Yeah, that's a really good question. So it's a bit unresolved, certainly, when you think about who is going to be an appropriate guardian and how would that be determined. So in the situation, for instance, with the Wanganui River, in that context, we've got a appointment of government and indigenous representatives who serve as the voice of the river there. And in that context, that makes sense because the protection of that river has to reflect a compromise between those competing interests for it to have a voice. One side was not going to concede to the other as the sole steward. When you think about certain types of animals that would require protection in the courts, there have been efforts to argue that someone who has devoted their career to a particular type of study that is supportive of that animal's conservation would be a good starting place, that this is someone who is trained in marine mammal sentience, for instance, and they're arguing on behalf of the whale who is being confined in a way that's harmful to the whale's mental and physical health. But it shouldn't be that narrow either. When you think about it, that couldn't an animal law professor be an effective guardian for that same exploited animal? Would it have to be someone trained in science? I don't think so. But I think this is really something where there's going to be an evolution in the courts in determining how guardianship is going to be determined in these circumstances. Because if we look at guardian ad litem systems across the country, there are different standards from state to state. Some guardian ad litems have to be trained in those areas that they're working in kind of childhood upbringing issues versus other states that just say it's anyone who's interested in helping out can be a guardian ad litem. So it's something that is going to be an ongoing discussion, and I don't think there's any one size fits all response, but I think certainly any value that environmental law, any guidance environmental law could offer would be valuable. I think because we have stewardship paradigms in both fields.
Great. Well, I hate to say we're out of time because this has been such a lovely conversation, but here we are. We need to wrap up today's talk. I want to thank you so much, Professor, for your presentation and your thoughtful fielding of those questions. It was really great to learn from your experience here. Thank you to all the viewers who joined us today. Our next talk in the series will take place in the same format on Friday, April 9th, and it will be with Professor Steve Wise, who Professor Abate mentioned today. He also works on animal personhood, and his talk will be titled The Struggle to Gain Legal Rights for Non-Human Animals. We hope you can join us then. Thank you, Professor Abate, and thank you everyone for joining us.
Thank you so much, Jenny.